First, I ask unanimous consent to enter into the record several letters in support of the CASE Act.
Without objection.
Thank you and congratulations, Mrs. Temple, on your permanent elevation to the position. Continue to appreciate the leadership that you provide. I want to thank my colleagues, Chairman Nadler, Chairman Johnson, Ted Lieu, Doug Collins, of course, Congresswoman Roby, and Congressman Klein for their support of the CASE Act. Mrs. Temple, has copyright infringement increased significantly over the last several years?
Well, that's, an issue that we have studied. I think according to some reports, yes, copyright infringement continues to increase steadily, and the type of copyright infringement changes, for example, from, illegal downloading to illegal streaming. So that's something that is a current concern because the more effective laws that we have, the more effective pirates are in trying to circumvent those laws.
And under current law, when there's a claim for copyright infringement, that of course must be heard in federal court, is that right?
Yes.
And that applies regardless of the amount in controversy, is that true?
Yes.
So if the amount in controversy is $5,000, if someone wants to vindicate that right, they still have to bring a federal court case, correct?
Right, yes.
Now, I think you mentioned earlier today that the average cost of litigating a case in federal court is approximately $200,000 if you take it to trial. Is that true?
Yes, yes.
So in many instances, the cost of litigating in federal court is often higher than the damages that one may be seeking as a petitioner. Is that true?
Yes, yes, it is.
So is it fair to say that as a result of this sort of vexing situation, you have creators, visual artists, others who are left with a right but no remedy to vindicate that right? Is that true?
Yeah, and that's one of our key conclusions.
And do you support sort of a less burdensome alternative, such as a small claims court-like tribunal housed within the Copyright Office?
Yes, and we issued a full report, as mentioned, recommending the creation of just such a court within the Copyright Office in 2013 with our small claims report.
And in terms of that 2013 report, that system that you recommended, I think, would be overseen by a panel of 3 copyright experts called the Copyright Claims Board?
I don't know if we called it the CCB, but yes, it would essentially be the same framework that is in actually the current CASE Act.
Okay. And it would allow petitioners and respondents to participate without an attorney and without necessarily appearing in court. Is that right?
Right, and that's the main purpose, allowing people to appear, for example, pro se, so they don't have to spend that $200,000. Also, they might be able to utilize, for example, law students who are able to come in and help them. And I know under the CASE Act, the claims attorneys who are part of that bill would also be able to help guide those who are pro se in how to file their claims as well, which will be a very helpful aspect of the law.
Also, do you think that there's value in having copyright experts who will be part of the tribunal sort of assess the merits of a case and determine what, if any, damages would be available in the context of a dispute? Yes,
copyright can often be very complex, and that is why we did recommend in our report that the CCB or the whatever small claims tribunal have a authority by having expertise in copyright law. So at least 2 of the people who would be appointed would actually have to have expertise, both representing copyright owners as well as users.
And I think the 2013 report also recommended considering imposing a ceiling on the damages, is that right?
Yes.
And as far as you understand it, does the CASE Act sort of incorporate those recommendations by setting a $30,000 cap for each dispute and $15,000 per work in terms of claims that are brought before the Copyright Review Board?
Yes, and that was our exact recommendation in our 2013 report.
Okay, and in terms of the importance of individual artists being able to vindicate their rights under copyright, could you just speak to the significance of it? Many of us have noted that Article 1, Section 8, Clause 8 of the United States Constitution, which gives Congress the power to regulate intellectual property law in order to promote the progress of science and useful arts, is sort of at the core of the founding of this nation. And so to have a circumstance where you have artists who have a right but no remedy and can't vindicate that right seems inconsistent with one of the foundational principles of the United States of America. But I'd be interested in your thoughts.
I couldn't say it any better. I will say that I certainly agree. We have recognized that individual artists and creators are really the backbone of our copyright ecosystem. And so having a system where those individual artists and creators aren't really able to participate and legally enforce their rights really isn't an adequate system at all. And that is why we do support a small claim, so that those individual artists and creators are able to have a forum in which they can vindicate their rights.
Thank you for your service. Thank you for your testimony. I yield back.